Hi, I'm Marty Judnich. I'm the president of the Judnich Law Office, and I want to talk to you today a little bit about all the things that have changed regarding expunging your misdemeanor criminal record in Montana. A lot has changed since 2017 when the expungement statute was enacted. Now in 2019 and moving forward, there's some big changes. So what can you do and what's it mean? Expungement technically means that the court will destroy and seal certain criminal records if you're successful petitioning them. Now in Montana, there's some big changes, and here they are. Number one, we can now expunge your entire misdemeanor record. That means speeding tickets, drug issues, anything with DMV, anything that's a misdemeanor. The bottom line is to be eligible for expungement, it simply has to be a misdemeanor. Felonies, not eligible for expungement. Any misdemeanor is eligible for expungement. And now under the new revised law, you can expunge every misdemeanor that's on your record, whether it be a recent conviction or something that's decades old. You can expunge it all. The trick is you only get one chance at expungement in Montana. So to be eligible, the eligibility requirements are: number one, you've never tried expungement before. You only get one bite at that apple. That means you better do it right. Hiring an experienced law office like us is probably a good idea if you want to make sure you get your one opportunity taken care of successfully. Number two, the other eligibility is that it's a misdemeanor. That's it. To be eligible, it's just a misdemeanor and you haven't filed for expungement before. So what's next? The other big changes are for the types of expungements that happen and what the court can consider. And we call that now presumed expungement and not presumed expungement. The difference is pretty significant. Now, for a presumed expungement, that pretty much means the court is going to grant the expungement. These are misdemeanors in the following cases. You don't have any other criminal convictions from at least 5 years past the completion of the sentence that you want to be expunged. What's that really mean? It means, let's say 6 years ago, you received a theft conviction and you have nothing else on your record. Well, that will be presumptively expunged because more than 5 years have gone by since the end of that sentence and you don't have another conviction. If you meet that eligibility criteria, that's the first level of a presumed expungement. The second criteria for a presumed expungement is it's any misdemeanor offense other than a DUI, certain types of assault, including partner or family member assault, or violation of restraining order, or DUI. So if it's not one of those, then presumption is assumed. So we're talking the vast amount of regular traffic that's not DUI, drug stuff, theft stuff, disorderly conduct, anything like that is a presumed expungement, and it's almost a guarantee that the court will agree to expunge that. So now the rest of it, the non-presumed expungements. What are those and what do they mean for you? This is the one where you can still get it expunged. However, the court has the discretion to say no, they're not going to expunge it. And that's situations and cases like this. Number one, you have a criminal conviction within 5 years from the sentence that you want to be expunged. So let's say you have that same theft conviction 6 years ago, but 3 years after that, you get another theft conviction, another whatever. It pretty much is anything other than traffic. If you have another criminal conviction, that now moves that original theft conviction into the category of not presumed. Now, all not presumed means is that the judge is going to take a look at it and get into some other factors that we're going to talk about when they determine if you should be granted an expungement for that conviction. The other type of eligibility for not presumed and cases that'll fall into the not presumed category is, like we talked about, ones where you have the conviction within 5 years of that date, and the types of categories of crimes that we talked about: DUI, assault type convictions, or violation of restraining order. If you have a DUI you want to get expunged, whether you have another conviction or not, whether you have an assault or partner family member assault and you don't have any convictions after that, all of those are the category of case that they put into the not presumed to be expunged. And the reason is this: in Montana, those kind of offenses, the more you get, the more we call stack. And so it means if you get more of them, the sentence gets worse and worse. And so most prosecutors and judges want to keep those on your record so that if you get another one in the future, they use the old one against you. And obviously, if you got it expunged, well, then they can't use it against you. However, the attorneys at the Judnich Law Office have been outrageously successful in getting DUIs expunged, partner assaults expunged, etc. So just because it's in the category of not presumed to be expunged does not mean it can't be expunged, and in a lot of cases it will be expunged. Once we file a petition, and let's say it is in the category of not presumed expunged, so what do we have to do? What do we have to show the court? The court's going to consider a lot of different factors to determine whether they're going to use their discretion to grant your expungement. Some of the things the court are going to factor in are your age when the crime was committed. Obviously, if you were a little young and dumb and you made some mistakes when you were younger, the court's going to factor that in greater than somebody that committed a crime late in their 20s, 30s, 40s, etc. The court sort of assumes if you were young and made some mistakes, that's more likely to get expungement granted than somebody that made a bigger mistake later in life. The court will also look at the time frame, or the amount of time that's gone by between when that old crime was committed and when you're petitioning the court for expungement. If you're right at that 5-year window and it's right the earliest time to expunge, they're going to factor that in and maybe not be as likely to grant that expungement versus somebody that's trying to get rid of, let's say, an old DUI case from 20 years ago. The length of time is important, and the judge is going to take that into consideration. Another type of factor that the judge is going to look at is the rehabilitation of the petitioner. That means, what'd you do to improve yourself since that conviction? Have you had any counseling? Have you gone to rehab? Have you done anything community service-wise to show that you've grown from that mistake and you've done positive steps from there? So a big factor is the rehabilitation. One of the last things the judge will look at is the likelihood of reoffending, and that's a difficult one to prove or establish. You need to show the court you're not likely to repeat the same mistakes you've made in the past, and show those are some of the things that the court is going to take into consideration for the not presumed expungements. The process of getting an expungement granted by a court is pretty complicated, and it goes all the way from the filing of a petition to having the correct legalese in your petition to providing the court all of the necessary information they need to make an informed decision. Having an experienced attorney do that for you is really paramount and important when you're considering doing it. There could be a hearing called, and at that hearing you're going to need to know what to do. Having an attorney by your side is always a great idea if you got to go in front of a court for a hearing for expungement. Lastly, what do you do with an order? How do you get an order? Experienced attorneys in expungement will know how to get the order from the court, and then the important part happens. Once you get the piece of paper that's the order granting your expungement, what happens then? It's not just magic that makes it all happen. You actually have to do something with the order to get the Department of Justice to expunge your record and get the various forms of government entities to then seal the rest of the records to make sure you're actually getting your convictions expunged. The attorneys here at the Judnich Law Office have a lot of experience, and we have a great track record expunging things for people to help them out with employment, housing, social stigma, and other things. We'd be happy to help you with your record, and you can check us out here online at judnichlaw.com. We have a free expungement eligibility tracker. You can plug your information into that, and we will respond to you and let you know what we can do, what we can't do for you, or you could just feel free to give us a call. We can give you a free consultation and let you know what's going on with the possibility of expungement, how much it costs, and everything else associated with it. So we hope we can help you out. I'm Marty Judnich with the Judnich Law Office.